Welcome back. I'm very glad today to introduce you Matteo Praturlon. Matteo is a lawyer, is very expert in tax law, and has agreed to hold this lecture for us, a very important lecture about OECD model tax convention. We would have preferred to have him physically in Trento, but current events do not allow it. Hopefully, in the next year, we hope. However, we are very grateful that he also wanted to participate to his course. And
well,
do you want
just a couple of things? First of all, I have to say thank you, Matteo. It's a colleague and friend, and is a very expert in tax law. Well, we have just finished a general overview of the legal framework of international tax law, and often we refer to the OECD model, the guidelines, the soft law that are very important to understand the meaning of the disposition in tax law, international tax law. And today we finally approach deeper the OECD model with a first part of lesson, if I could correctly understand, of a general overview of the model, and then we will go deeper and deeper in different and specific disposition. So thank you, Matteo, and the phone is yours.
Thank you for this invitation, and I can start my relation. Well, what is OECD? The Organization for Economic Cooperation and Development, OECD, is an international organization founded in 1961 to stimulate economic progress and world trade. It works to build better policies for improving economic performance, creating jobs, fostering strong education, and fighting international tax evasion, together with governments, policymakers, and citizens. It provides a unique forum and knowledge hub for data and analysis and international standard setting. It is at the forefront of efforts to improve international tax cooperation between governments to counter international tax avoidance and evasion. What's the international juridical double taxation? International juridical double taxation can be generally defined as the imposition of comparable taxes in two or more states on the same taxpayer in respect of the same subject matter and for identical periods. Its harmful effects on the exchange of goods and services and movements of capital, technology, and persons are so well known that it is scarcely necessary to stress the importance of removing the obstacles that double taxation presents to the development of economic relations between countries. What are the main purposes in the field of international juridical double taxation? It has long been recognized among the member countries of the Organization for Economic Cooperation and Development that it's desirable to clarify, standardize, and confirm the fiscal situation of taxpayers who are engaged in commercial, industrial, financial, or any other activities in other countries through the application by all countries of common solution to identical cases of double taxation. What is the OECD Model Tax Convention? The OECD Model Tax Convention is a model for countries concluding bilateral tax conventions, which plays crucial role in removing tax-related barriers to cross-border trade and investment. It is the basis for negotiation and application of bilateral tax treaties between countries, designed to assist business while helping to prevent tax evasion and avoidance. The OECD model requires constant review to address the new tax issues that arise in connection with the evolution of the global economy. Last update was published in 2017. Most notably, it has been used as the basis for the original drafting and the subsequent revision of the United Nations Model Double Taxation Convention between developed and developing countries, which reproduces a significant part of the provisions and commentaries of the OECD Model Convention. The worldwide recognition of the provision of the Model Convention and their incorporation into a majority of bilateral conventions have helped make the commentaries on the provisions of existing bilateral conventions. What does the Model Tax Convention and its commentaries provide? The OECD Model Tax Convention on income and on capital provides some means of settling on a uniform basis the most common problems that arise in the field of international juridical double taxation. As recommended by the Council of the OECD, member countries, when completing or revising bilateral conventions, should conform to this model convention as interpreted by the commentaries thereon, and having regard the reservation therein, and their tax authorities should follow these commentaries as modified from time to time and subject to their observation thereon, when applying and interpreting the provision of their bilateral tax convention that are based on the Model Convention. The Model Convention seeks, wherever possible, to specify for each situation a single rule. On certain points, however, it was thought necessary to leave in the Convention a certain degree of flexibility, compatible with the efficient implementation of the Model Convention. Member countries therefore enjoy a certain latitude, for example, with regards to fixing the rate of tax source on dividends and interest, and the choice of method for eliminating double taxation. What are Model Tax Convention commentaries? For each article in the convention, there is a detailed commentary that is intended to illustrate or interpret its provisions. Commentaries are of special importance in the development of international fiscal law. Although the commentaries are not designed to be annexed in any manner to the convention signed by member countries, which, unlike the model, are legally binding international instruments, they can nevertheless be a great assistance in the application and interpretation of the convention, and in particular in the settlement of any disputes. The tax administration of member countries routinely consults the commentaries in their interpretation of bilateral tax treaties. Taxpayers make extensive use of the commentaries in conducting their business and planning their business transactions and investments. Also, judicial courts are increasingly using commentaries in reaching their decisions. In the commentaries, there are a lot of reservations of certain member countries. Although all member countries are in agreement with the aims and the main provisions of the Model Convention, nearly all have entered reservation on some provisions, which are recorded in the commentaries on the article concerned. It is understood that insofar as a member country has entered reservations, the other member countries, in negotiating bilateral conventions with the former, will retain their freedom of action in accordance with the principle of reciprocity. What is the OECD model tax structure? The Model Convention first describes its scope in Chapter 1 and defines some terms in Chapter 2. The main part is made up of Chapter 3 to 5, which settle to what extent each of the two contracting states may tax income and capital, and how international juridical double taxation is to be eliminated. Then follow the special provisions in Chapter 6 and the final provisions, entry into force and termination, Chapter 7. What are the OECD tax model convention scope and definitions? First, the conventions apply to all persons who are residents of one or both of the contracting states. Article 1 and Article 4. It deals with taxes on income and on capital, which are described in a general way in Article 2. In Chapter 2, some terms used in more than one article of the Convention are defined. Other terms, such as dividends, interests, royalties, and immovable property, are defined in the articles that deal with these matters. For the purpose of eliminating double taxation, the Convention established two categories of rules. First rules, with regard to different classes of income, OECD model determine right to tax of the state of source or place and of the state of residence. It is the same with regard to capital. In the case of a number of items of income and capital, an exclusive right tax is conferred on one of the contracting states. The other contracting states is thereby prevented from taxing those items, and double taxation is so avoided. As a rule, this exclusive right to tax is conferred on the state of residence. Second rule, insofar as these provisions confer on the state of source or place of immovable property a full or limited right to tax. The state of residence must allow reliefs so as to avoid double taxation. The Convention leaves it to the contracting states to choose between two methods of relief, i.e. the exemptions method on the credit method. What are income and capital categories? Income and capital may be classified into three classes, depending on the treatment applicable to each class in the state of source or site. First, Article 6 to 21 determine, with regard to different classes of income, the respective rights to tax of the state of source or place for immovable property and of the state of residence. And Article 22 does the same with regard to capital. In the case of a number of items of income and capital, a necessary right to tax is conferred on one of the contracting states. Income and capital that may be taxed without any limitation in the state of source or place. For example, income from immovable property situated in that state, including income from agriculture or forestry, gains from the alienation of such property, and capital representing it, as well as gains from the alienation of share deriving more than 50% of their value from such property. Profits of a permanent establishment situated in that state, gains from the alienation of such a permanent establishment, and the capital representative movable property forming part of the business property of such a permanent establishment. Income from activities of entertainers and sports persons exercised in that state, irrespective of whether such income accrues to the artist or sportsman himself or to another person. Another example is about director's fee paid by a company that is a resident of the state. Remuneration in respect of an employment in the private sector exercised in the state, unless the employee is present therein for a period not exceeding 183 days in any 12-month period commencing or ending in the fiscal year concerned, and certain conditions are met. The second category is income that may be subjected to limited taxation in the state of source. For example, dividends provided the holding respect and interest if certain conditions are met established in Articles 10 and 11 of the Model Convention. The third category is income and capital that may not be taxed in the state of source or place. As a rule, they are taxable only in the state of residence of the taxpayers. This applies, for example, royalties, gains from the alienation of shares or securities, remuneration in respect of an employment exercised aboard a ship or an aircraft, already in international traffic, private sector pensions. Also, business profits that are not attributable to a permanent establishment in the state of source are also taxable only in the state of residence. What are double taxation solutions? Where residents of a contracting state receives income from sources in the other contracting state or owns capital situated therein, that is in accordance with the convention, is taxable only in the state of residence. Sorry. No problem of double taxation arises, since the state of source or site must refrain from taxing that income or capital. Where, on the contrary, income or capital may, in accordance with the convention, be taxed with or without limitation in the state of source or site, the state of residence has the obligation to eliminate double taxation. This can be accomplished by one of the following two methods: exemptions method and credit method. What is exemptions method? In this case, income or capital that is taxable in the state of source or site is exempted in the state of residence, but it may be taken into account in determining the rate of tax applicable to the taxpayer's remaining income or capital. The second solution is credit method. Income or capital that is taxable in the state of source or site is subject to tax in the state of residence, but the tax levied in the state of source or site is credited against the tax levied by the state or of residence on such income or capital. You have to note that throughout the convention, the words may be taxing in a contracting state mean that that state is granted the right to tax the income which the relevant provision applies, and that these words do not affect the right to tax of the other contracting states, except through the application of Article 23A or 23B, when that other state is the state of residence. There are a number of special provisions in the Convention. These provisions concern Article 24, the elimination of tax discrimination in various circumstances. Article 25, the establishment of a mutual agreement procedure for eliminating double taxation and resolving conflicts of interpretation of the Convention between tax authorities. Article 26, the exchange of information between the tax authorities of the contracting states. Article 27, the assistance by contracting states in the collection of each other's taxes. Article 28, the tax treatment of members of diplomatic missions and consular posts in accordance with international law. Article 29, the entitlement to the benefits of the Convention. Article 30, the territorial extension of the Convention. Io avrei finito,